I won the lottery! I won $1.3 billion! I want a divorce.
11 days. That's how long Denise Rossi waited between the phone call that told her she'd won more than $1 million and the morning she walked into a courthouse and filed for divorce. She never mentioned the money. Not to her husband of 25 years, not to her own attorney, not to the court that legally required her to disclose it. It would take almost 3 years, one misdirected letter, and a judge who did not believe her story about a gift, before the truth caught up with her. And when it did, it cost her every single dollar she tried to keep. Denise and Thomas Rossi were married in 1971, at a time when neither of them could have imagined their names would one day sit at the center of a California appellate court decision, studied by law students for decades. By 1996, they had built a life together that spanned 25 years, the kind of marriage where finances, property, and daily routine had long since become fully intertwined. Denise worked alongside a group of coworkers, one of whom, a woman named Bernadette Curcio, had a habit that would end up changing several lives that November. Curcio decided to start a small office lottery pool, inviting her coworkers to chip in a few dollars each week for a shared shot at a jackpot most people only ever imagine winning. Denise joined in. According to court records, she contributed $5 a week to the pool for approximately 3 weeks in November of 1996, a modest and unremarkable habit shared by millions of office workers across the country. Then, on or around December 1, 1996, Denise withdrew from the pool. She would later tell the court this was simply a personal decision, unconnected to anything she knew or suspected about the group's odds. It is a detail that, on its own, would have meant nothing at all. Office lottery pools form and dissolve constantly, and most participants drift in and out without a second thought. But this particular withdrawal would become one of the most scrutinized details in the entire case, because of what happened only a few weeks later. In late December of 1996, Bernadette Curcio called Denise with news that would upend both of their lives. The pool had won. Not a modest consolation prize, but a genuine jackpot. $6,680,000, split among the group of coworkers who had stayed in. Denise, despite having withdrawn from the pool weeks earlier, was told she still had a share coming to her, $1,336,000, payable in 20 annual installments of $66,800 before taxes, stretching from 1996 all the way through 2015. Both Curcio and Denise would later tell the court that Curcio had decided, out of generosity, to treat Denise's earlier contribution as if it still counted, offering her a share as what they both later described as a gift. Whatever the truth of that generosity, Denise now had a decision to make, and the decision she made would define the rest of the case. She did not tell her husband. She did not update her attorney, who at that point had no reason to think anything unusual was happening in the Rossi household. Instead, according to the court record, Denise went directly to the California Lottery Commission's offices and had a conversation that would later be read back to her, almost word for word, in a courtroom. She told lottery officials that she was married but contemplating divorce, and asked how she might structure the payments in a way that would keep her husband from learning about or claiming any share of her winnings. That conversation set the blueprint for everything that followed. Denise arranged for her lottery correspondence, including her checks, to be sent not to the home she shared with Thomas, but to her mother's address across town. It was a simple, almost mundane piece of misdirection, the kind of small logistical choice that, multiplied across nearly 3 years, kept an enormous secret completely intact. With her mail rerouted and her plan in motion, Denise filed for divorce from Thomas just 11 days after learning of the win. To Thomas, at the time, the timing looked unremarkable. Marriages end for all kinds of reasons, and a 25-year relationship reaching its conclusion did not, on its face, need any hidden explanation. What Thomas did not know was that California, like every community property state, imposes a strict legal duty on divorcing spouses to disclose the full and complete picture of their finances, including any windfall acquired during the marriage. This obligation isn't a courtesy. It's codified in the state's family code, under sections that require both parties to a divorce to fully and accurately disclose all assets, income, and property, whether or not the other spouse specifically asks about them. The law places the burden on the person who has better access to the information, precisely because one spouse can so easily know things the other cannot. Denise, at every stage of her divorce filings, her financial declarations, and her marital settlement agreement, said nothing about the winnings. Not once. The divorce proceeded exactly as Denise had hoped it would. Thomas signed a marital settlement agreement believing he had a complete and honest picture of what he and his wife had built and were now dividing. He walked away from 25 years of marriage with a settlement based entirely on the assets he knew existed, unaware that somewhere across town, in his mother-in-law's mailbox, an entirely separate fortune was quietly accumulating in his ex-wife's name. For most people, this is where a story like this would simply end. The divorce was final. The paperwork was signed. Two lives moved on in separate directions, and the truth, absent an extraordinary coincidence, might never have surfaced at all. But extraordinary coincidences do happen, and in this case, it came in the form of a piece of junk mail. Roughly 2 to 3 years after the divorce was finalized, a company that specializes in offering lottery winners a lump sum cash payment in exchange for their future annual installments sent a solicitation letter. That letter was addressed to Denise, and it referenced her lottery winnings directly, describing how the company had helped other winners access the present-day value of their future payments. Through a mistake in address records, or perhaps simple bad luck for Denise, that letter ended up in front of Thomas instead of his ex-wife. He opened it expecting nothing in particular, and found himself reading a sentence that referenced winnings he had never once heard mentioned during their entire marriage or their divorce. It is hard to overstate how disorienting a discovery like that must have been. Thomas had spent years operating under the belief that he understood, completely, the financial reality of the life he and Denise had shared, and then divided. Now he was holding physical proof that an entire fortune, generated during their marriage and legally subject to disclosure, had existed the whole time and had simply never been mentioned. Later, speaking to reporters, Thomas described his reaction to learning why Denise had wanted to move so quickly and so decisively to end their marriage. For years, her urgency had never quite made sense to him. Now, suddenly, it did. Thomas did not let the matter drop. He retained legal counsel and moved to reopen the case, filing a motion asking the court to set aside the original divorce judgment entirely on the grounds of fraud and breach of fiduciary duty. This was not a small or symbolic legal maneuver. Under California's family code, a spouse who intentionally conceals a community property asset during divorce proceedings can, in certain circumstances, be required to forfeit their entire share of that asset to the other spouse, as a penalty specifically designed to punish concealment and protect the integrity of the disclosure process. Thomas's attorneys argued that Denise's conduct was a textbook example of exactly the kind of concealment those laws existed to prevent. Denise's defense, when the case reached the family court, rested on a single central claim, that the money was never marital property to begin with. She argued that Bernadette Corsio's gift of a share, made after Denise had already withdrawn from the pool, meant the winnings were her own separate property, not something acquired jointly during the marriage, and therefore not something she was under any obligation to disclose or divide. If the court accepted that framing, her failure to mention the winnings would look less like fraud and more like a private citizen, simply managing money that was legally and entirely her own. The court did not accept it. In direct and unambiguous language, the family court stated for the record that it did not believe the story about the gift, finding instead that the funds used to purchase the winning ticket were community property, generated and shared within the marriage regardless of Denise's brief withdrawal from the office pool. This finding mattered enormously, because it meant the court viewed Denise not as a woman managing her own separate money, but as a spouse who had deliberately hidden a jointly owned asset from both her husband and the legal system responsible for dividing it fairly. Having rejected the gift defense, the court moved to the heart of the matter, whether Denise's conduct rose to the level of legal fraud. Under California's Civil Code, fraud in this context requires more than simple failure to disclose. It requires oppression and malice, a level of deliberate, knowing deception that goes beyond an honest mistake or a gray area in the law. The court found that Denise met that standard. It pointed specifically to her visit to the Lottery Commission, where she had asked, in plain terms, how to structure her payments so her husband would never find out. That single conversation transformed the case from an ambiguous dispute over asset classification into a clear-cut finding of intentional concealment. On appeal, Denise's legal team tried a different strategy entirely, one that revealed a far more difficult and complicated picture of the marriage than the simple story of a woman who got lucky and got greedy. Her attorneys argued that Thomas himself had unclean hands, a legal doctrine that can bar a party from receiving equitable relief if they themselves acted improperly. According to her appellate filings, Denise's legal team described her as a woman who had endured both physical and emotional abuse throughout the marriage, and alleged that Thomas's own gambling and financial mismanagement had caused the family's finances to deteriorate to the point of bankruptcy. Her filings went further still, alleging that Thomas had, at points during their marriage, threatened her life. These were serious allegations, and it's important to be precise about what the court actually decided regarding them. The appellate court's ruling did not turn on whether those specific claims about abuse and threats were true or false. The court's central finding remained focused on the credibility of the gift story and the intentional nature of the concealment itself, and it found Denise's account there was not believable. The broader allegations about the marriage's difficulties remain, in the historical record, exactly what they were: claims made by one side in a contested legal filing, not independently verified facts established by the court. What the case does make clear is that behind the simplified headline of a woman hiding lottery winnings, there may have been a far more layered and difficult marriage than a single dramatic detail can capture. Regardless of how the marriage itself is ultimately understood, the court's ruling on the central legal question was unequivocal. The family court found that Denise had breached her fiduciary duties under multiple sections of California's Family Code, had intentionally violated the warranties and representations she'd made in the marital settlement agreement, and had committed fraud within the meaning of the law. As a penalty, the court awarded Thomas 100% of the concealed lottery winnings, the full $1,336,000, structured as the same 20 annual installments Denise had once hoped to keep entirely to herself. In June of 2001, the California Court of Appeal affirmed that ruling in full, rejecting every argument Denise's attorneys raised and cementing the outcome as final. The financial consequence for Denise was total. She did not lose half of the winnings, or a negotiated portion reflecting some shared blame. She lost all of it, every scheduled payment for 19 years running, transferred by court order to the very person she had structured an entire secret system to keep it from. Family law attorneys who have written about the case in the years since have consistently pointed to one detail as the most painful irony of all. Had Denise simply disclosed the winnings honestly at the time of the divorce, legal analysts who later reviewed the case noted she likely could have kept at least a meaningful portion of it, potentially arguing successfully that Curcio's gift made some or all of it her separate property. Instead, the act of hiding the asset, not the asset itself, is what cost her everything. What makes this case endure, more than 2 decades after the underlying events took place, is not simply its dramatic details. It's the fact that in Ray marriage of Rossi went on to become a foundational citation in California family law, referenced in subsequent cases dealing with asset concealment and fiduciary duty during divorce, and taught in law schools as a clear, real-world illustration of exactly how far courts are willing to go to punish spouses who try to game the disclosure process. Legal commentators have described it as a cautionary tale precisely because the underlying temptation it illustrates is so universally understandable. Anyone who has ever gone through a divorce, or watched someone close to them go through one, can imagine the fleeting human impulse to keep one thing, just one thing, entirely to themselves. That impulse, it turns out, is far more common than most people assume. National research on financial behavior within marriages has found that a striking percentage of spouses, estimates run as high as roughly 40%, admit to some form of financial deception against their partner at some point in the relationship, ranging from hidden purchases and secret credit cards to concealed savings accounts, and in rarer and more extreme cases, entire hidden windfalls. Surveys on the subject have found that discovering this kind of deception erodes trust in roughly a third of couples who experience it, and that for a meaningful share of them, it becomes the specific event that ends the relationship entirely. Denise Rossi's case simply represents the furthest, most consequential edge of a pattern that touches far more marriages than most people would ever guess. It also illustrates something else, something more structural about how divorce law actually functions. Courts do not rely on trust alone to divide marital property fairly. They rely on legally enforced disclosure obligations, on the threat of exactly the kind of forfeiture penalty Denise faced, and when suspicion arises, on forensic accountants trained specifically to trace hidden income, undisclosed accounts, and concealed windfalls that one spouse hoped the other would never find. Family law attorneys describe these specialists as financial detectives, capable of reconstructing a paper trail even when someone has gone to real lengths, as Denise did, to keep that trail hidden. The system is built, deliberately, around the assumption that concealment will eventually be attempted, and around consequences severe enough to make that attempt not worth the risk. Denise Rossi's case is not, in the years since, an isolated curiosity either. Similar disputes have surfaced in other lottery-heavy states, including a case out of Idaho involving a Mega Millions jackpot winner, whose complicated marital history immediately raised the same underlying legal question Rossi's case had already answered years earlier. Who, precisely, is entitled to windfall winnings when a marriage is in the process of ending? And what happens when one spouse tries to control that answer by controlling what the other spouse is allowed to know? Family law practitioners have continued to cite the Rossi decision directly in analyzing these newer disputes, treating it as settled precedent for just how seriously courts will treat concealment, regardless of how the underlying asset was acquired. There is a quieter question sitting underneath all of the legal precedent and financial detail, one that has nothing to do with statutes or appellate rulings. It's the question of what, exactly, Denise Rossi thought would happen. Whether she believed the secret would simply hold forever, or whether some part of her understood, even as she stood in the Lottery Commission's office asking how to keep her husband from finding out, that a decision like that rarely stays buried for 2.5 decades, let alone 2.5 years. The record doesn't answer that question, and it likely never will. What the record does show, with total clarity, is the exact moment the secret stopped being hers to keep. A single misdirected envelope, sent to the wrong house, that undid nearly 3 years of careful, deliberate concealment in the time it took one man to open his mail. If you take one thing away from Denise Rossi's story, let it be this. In the eyes of the law, a marriage's financial obligations don't end the moment two people stop loving each other, or even the moment they sign a settlement agreement. They end only when both people have told each other, and told the court, the complete truth about what they had. Denise Rossi believed she'd found a way around that requirement. For nearly 3 years, she was right. And then, for the rest of her life, The law made absolutely certain she understood exactly how wrong she'd actually been before. We dive deeper. Let us know in the comments where you're watching from. We'd love to hear from you. And don't forget to hit that subscribe button so you never miss any of our upcoming videos. There's a version of this story that ends differently, and it's worth sitting with for a moment because it says as much about the law as the actual outcome does. If Denise had walked into that same divorce with the same winnings and simply told the truth, family law analysts who have studied the case since agree she had a genuinely strong argument available to her. A share of lottery winnings gifted specifically to her, after she'd already withdrawn from the office pool, is exactly the kind of asset California law recognizes as separate property under the right circumstances, meaning it may never have been subject to division with Thomas at all. She might have kept some, or even most, of what she'd won, legally and without controversy. The secrecy wasn't a shortcut to protecting her winnings. It was the single decision that guaranteed she'd lose every dollar of them. That distinction, the gap between what honesty might have preserved and what concealment actually destroyed, sits at the center of nearly every hidden asset divorce case that has followed in Rossi's wake. Family law attorneys frequently point new clients toward this exact case when explaining why full disclosure, even when it feels personally costly in the moment, is almost always the legally safer path. The emotional logic of hiding an asset makes a certain intuitive sense in the middle of a painful divorce. If he doesn't know about it, he can't ask for it. But the legal system was built, deliberately and specifically, to punish that exact logic more severely than it punishes almost anything else in a divorce proceeding, precisely because the entire structure of equitable property division depends on both spouses telling the truth. It's also worth pausing on what this case reveals about the mechanics of discovery itself, because so much of what makes it compelling is how ordinary the moment of exposure actually was. This wasn't a private investigator hired to dig through bank records. It wasn't a forensic accountant poring over years of statements looking for irregularities. It was a piece of marketing mail from a company trying to sell a financial product, sent to the wrong address by simple administrative error. Nearly 3 years of careful planning, a rerouted mailing address, a direct conversation with lottery officials about how to keep a spouse in the dark. All of it came apart because of a mistake as mundane as a mail carrier delivering an envelope to the wrong door. There's something almost unbearably human in that detail. Denise Rossi had, by every account in the legal record, been remarkably thorough. She hadn't simply failed to mention the winnings out of carelessness or oversight. She had actively sought guidance on how to conceal them, structured her mail specifically to avoid detection, and maintained that concealment consistently through an entire divorce proceeding, financial declarations and all. And still, despite all of that deliberate effort, the truth found its way to Thomas anyway, through the most unremarkable channel imaginable. It's a reminder that even carefully constructed secrets tend to depend on a level of control over information that almost nobody actually has, indefinitely, over a period of years. For Thomas, the discovery reopened not just a legal case, but an entire chapter of his life he thought had already closed. He had, by his own account to reporters afterward, spent years genuinely confused about why his wife of 25 years had suddenly wanted out of their marriage with such urgency. That confusion, in hindsight, had an answer all along, one that had simply been kept from him. Learning it years later didn't just correct a factual gap. It reframed an entire period of his life, turning a decision he'd once accepted as simply one of those things that happens in long marriages into something he now understood had been deliberately engineered around a secret he was never meant to find. The court's decision to award him the full amount, rather than some negotiated split reflecting shared responsibility for how the marriage ended, sent a clear message that extended well beyond the Rossi case itself. California's family code doesn't simply encourage honesty during divorce. It backs that expectation with a penalty severe enough to make concealment, even successful concealment lasting years, financially catastrophic the moment it's discovered. That structure exists because the alternative, a system where hidden assets simply become the property of whoever successfully hides them long enough, would make full and fair disclosure essentially optional, undermining the entire premise on which equitable divorce settlements are supposed to be built. More than 2 decades on, Denise Rossi's name remains attached to one of the most frequently cited cautionary tales in American family law, not because the amount of money involved was extraordinary by the standards of wealthy divorces, but because the mechanics of the deception and the totality of its unraveling are so cleanly and completely documented. Every stage of the story exists in the public record. The office pool, the withdrawal, the phone call from Bernadette Corcio, the visit to the lottery commission, the rerouted mail, the swift divorce filing, the years of silence, the misdirected letter, and finally, the courtroom finding that ended it all. Few cases offer such a complete and traceable arc from secret to consequence. What lingers, long after the legal details fade, is the sheer scale of the miscalculation at the center of it. Denise Rossi didn't lose a portion of her winnings to a hostile ex-husband in a contentious legal battle over who deserved what. She lost the entire amount, all 20 installments, as a direct and specific penalty for the decision to hide it in the first place. In trying to guarantee she would walk away with something entirely her own, she guaranteed instead that she would walk away with nothing at all. And somewhere in that outcome is a truth that extends well beyond lottery winnings, well beyond California family law, and well beyond one marriage that ended in 1996. The things people try hardest to hide are so often the very things that end up costing them the most. Before we dive deeper, let us know in the comments where you're watching from. We'd love to hear from you. And don't forget to hit that subscribe button so you never miss any of our upcoming videos.